Well, hello everybody, and a very warm welcome to this Refugee Law Initiative conference thematic panel on the complementary role of other legal approaches in protecting refugees. My name is Professor David Cantor, and I'm the Director of the Refugee Law Initiative. Unfortunately, our advertised chair was caught short just before the panel started, and I'm stepping in to chair in her stead. The global legal regime for refugee protection extends beyond just international refugee law in its strict sense. And the idea of this panel is to explore the complementary role that other legal approaches can offer in improving the protection of refugees worldwide. It brings together 4 separate papers submitted to the conference call for papers, and full details of the papers and presenters can be found in your conference programme. Our speakers today will start off by presenting key perspectives on 4 quite different components of this issue, after which we're going to open up for broader discussion, questions and comments from other participants. Each of the 4 speakers will have 10 minutes for their presentation, which I'll be enforcing strictly, and during the session, if you can please pose your own questions and comments to the speakers by typing them into the chat box on Zoom, making sure that they are seeable or viewable by everyone. After speakers have finished their presentations, there'll be time for them to discuss and reflect on your questions and comments. The session's being recorded, and with the consent of the speakers will be posted on the RLI website as a podcast. If you don't wish to appear in the podcast, then please leave the session now. If you wish to hide the live transcript that may be appearing at the bottom of your screen, you can click on the Hide Subtitles button. So without further ado, we turn to our first speaker, who is Catherine de Sousa Santos of the Universidade Católica de Santos, Brazil, who's presenting a paper that she's developed jointly with Professor Liliana Lira Jubilut, and the title of the paper is Humanitarian Visas in Latin America, Improving Refugee Protection. Over to you, Catherine.
Good afternoon. Here in Brazil, still good morning. Let's start by sharing my presentation. So let me start by apologizing for Professor Dr. Liliana Jubilut's absence, who unfortunately recently lost her father and couldn't make it today. But let us try to well represent her. Let me try, right? So humanitarian visas in Latin America, improving refugee protection, analyzes national systems of protection in the region, considering that despite not existing a binding regional normative on this topic, several Latin American states have created humanitarian visas or facilitated entry, stay, or temporary residency based on humanitarian grounds. In fact, in the last 2 decades, several Latin American states have either created or reviewed their national legislations on migration and adding provisions of protection based on humanitarian grounds. Humanitarian visas integrates the notion of complementary pathway as part of humanitarian admission programs, aiming to provide safer travels and alleviate the need of dangerous journeys and by those who need to migrate, forced to migrate. This initiative may be pointed out as a regional good example and arises the question whether it can improve refugee protection. So first of all, now let me start by saying that humanitarian visas in Latin America this application has been an ad hoc application, and by such states have been issuing visas and permits to attend specific contexts, such as the situation of Haiti, Syria, Venezuela, Afghanistan, and now more recently, Ukraine. This ad hoc application can be pointed out as a shortcoming, one of the identified shortcomings by our research. As such, because of it might be understood as a violation of principles of non-discrimination and equality, equality. So other shortcomings that might be pointed out in this opportunity is the fact that some decrees in some normatives throughout Latin America regarding humanitarian visas concession refers to nationality, specific nationalities as eligibility criteria, which may reinforce discrimination. So this is a very problematic situation that's been highlighted by the academia, because, for example, we have the Ukraine situation right now that Brazil has issued a special visa, a special humanitarian visa, and in Brazilian's decree, there is this reference to Ukrainians. So restrictive interpretation might left out others affected by the Ukrainian context. Besides, we have the administrative nature of humanitarian visas in Latin America. Considering that the establishment of humanitarian visas occurs through normative resolutions of administrative organs of the executive, as presented in Brazilian context also, and expose the sometimes political nature of these humanitarian measures. As such, humanitarian visas often relies on this political, on the political will of governments, and to stay valid with constant risk of revocation, expiration, or amendments, and it creates an uncertainty and legal insecurity. Alongside these shortcomings, what could be described as an additional shortcoming is actually what's referenced as additional barriers, which could be identified as the requirements that that are not listed in the decrees and the normatives, but are required to migrants by the diplomatic authorities. Like, for instance, we have the Afghans who are asked to present a sponsor to access humanitarian visas. And this provision, this requirement, it's not presented in the legislation, in those normatives that created the humanitarian visas. So these additional barriers can be very problematic, and also creates legal insecurity. So there's plenty of other shortcomings and developments that we could go on, but I think that would be very interesting to present this data over states and which measure they're presenting at the moment, considering that humanitarian visa, it is a measure that it's being created and being granted by many Latin American states, but not by all. So some states, as Panama, for instance, or El Salvador, don't have this provision, but Argentina and Brazil do. They have humanitarian visa. Brazil specifically has created a humanitarian visa for to address several situations, several contexts, such as the already mentioned context of Haiti, Syria, Venezuela, Afghanistan, and now more recently Ukraine. Therefore, considering I believe my short time here and what we have already developed in our research, I think that's what I'm bringing today, and hopefully we'll be addressing this after in the discussion part of this panel. I would like to thank you all for the opportunity and for the patience with this tryout to present this paper. So I'll let, okay, so I will end up here. And thank you once again for the opportunity.
Many thanks indeed, Catherine. So there you have for the first paper an overview of a really different way of providing humanitarian protection to those who may be at risk through humanitarian visas, which are domestic legal measures without any substantive reference, it sounds like, to international rules. Moving on from that, to think perhaps more about complementary routes at the international level, I'm really delighted to welcome our second speaker to the platform, and that is Dr. Gillian Kane of Queen's University Belfast, UK, and she'll be talking to the title of Enhancing Refugee Protection, Why We Need to Talk About Anti-Trafficking Law. Over to you, Gillian.
Thanks very much, David, and thanks to everyone for coming along this afternoon. My name is Gillian, and I am going to be presenting a paper today, really, which at its core responds to the question of what needs to be changed within the global refugee regime, by not looking at reform as such, but actually arguing that a broader approach, and in this case, one that more concretely embraces international anti-trafficking law, is needed. So really what I'm calling for is a closer engagement with existing international obligations, which sometimes stay on the periphery, but do have the capacity to enhance protection within the global refugee regime.
Gillian, I think we've lost you. Gillian? Hello? Oh dear, it looks like we may well have lost Gillian temporarily. So if that's the case, then I suggest that we proceed to our next speaker. I wonder, is it possible to stop screen sharing? Jane, do you know if perhaps we could remove the permissions? Thank you very much. Okay, so I'm going to move on in that case. Without further ado, we'll come back to Gillian on this important point, perhaps after our next speaker or further towards the end of the session. And I'm going to move directly on now to welcome Francesca Romana Partipillo, who's part of the Sant'Anna School of Advanced Studies in Italy. We're really very pleased to have you with us, presenting a very topical paper on the war in Ukraine and the Temporary Protection Directive, Lex Specialis, or a surreptitious innovation of refugee law. On that intriguing title, over to you.
Yes, thank you. Thank you, Professor Cantor. You were one of the few people ever who actually got my surname right the first time, and that's really difficult even for Italian speakers. So congratulations. So yeah, I will be speaking about the Temporary Protection Directive, which was activated on the 4th of March, last March, by the Council of the European Union in the wake of the Russian Federation's invasion of Ukraine, and given the rapidly deteriorating humanitarian situation on the ground. So we would all be quite comfortable in saying that the Temporary Protection Directive, the relationship between the Temporary Protection Directive and the global regime on asylum falls within the sphere of application of the Lex Specialis principle. This means that the Temporary Protection Directive should be applied within the confines of the general standard represented by the Geneva Convention and by the EU Qualification Directive in the European legal space. However, and this is also confirmed by the directive itself, which stipulates that temporary protection shall not prejudice the recognition of refugee status under the Geneva Convention. However, there are some observations which would suggest that the activation of the Temporary Protection Directive in the EU was rather motivated by a perceived inadequacy of the global asylum regime in dealing with situations of mass displacement. Let's analyze some numbers. As of today, the EU hosts almost 5 million refugees from Ukraine. with Eastern European countries such as Poland, Slovakia, Romania, Bulgaria, and Hungary receiving the highest number of refugees. Official statistics report that 1 million persons are registered as refugees in Poland only. Despite the openness with which European Eastern countries have welcomed refugees, most of the work, at least initially, has been done by civil society organizations, NGOs, churches, and even private citizens. In Poland, for example, while the state has provided resources and coordinated efforts, much of the initial burden was actually fell on civil society alone. This was caused by the fact that countries in Eastern Europe did not have the tools to cope with such a high influx of refugees before the war. However, this also demonstrates, in my opinion, that national capacities might be scaled up quickly also in the face of serious crisis. But faced with this kind of institutional unpreparedness, one might ask, why is the Temporary Protection Directive better suited to deal with mass influx situations than the traditional asylum regime? And why did the EU need such an instrument? To answer this question, we need to analyze some of the differences between the Temporary Protection Directive and the Geneva Convention. Temporary protection is a way to provide immediate protection to people fleeing a specific geographical area, providing everyone falling within its scope with the same rights across the European Union in our case. So, for example, a stay permit, a work permit, social assistance, and so on. When compared to the procedure to apply for refugee status, applying to temporary protection is rather easy and unbureaucratic. This is due to the fact that, according to the Geneva Convention, the determination on whether a person is to be considered as a refugee involves an individualized assessment, while under temporary protection, everyone coming from a specific region or a specific geographical area is included in the protection offered by temporary protection schemes. Consequently, this means that the Temporary Protection Directive grants a collective protection rather than an individualized type of protection as the one offered by the Geneva Convention. And this also means that a refugee claim might result much more difficult to substantiate in practice than a temporary protection application. And in addition, from a procedural standpoint, the process to apply to temporary protection is way faster. And of course, this means that national administrative and asylum systems will be shielded from the crisis. They will not receive a massive number of asylum applications, which would be impossible to process. However, as anticipated, the Temporary Protection Directive does not derogate from member states' international obligations in the field of refugee law. So the directive itself specifies that temporary protection should be compatible with member states' international legal obligations in the field of refugee law. And this means that after the expiration of the temporary protection status, and even during the enjoyment of temporary protection, people have to be free to apply for asylum in the country where they reside. Taking into consideration these observations, why, if the relationship between the Geneva Convention on one hand and the Temporary Protection Directive on the other is so well sorted out already in the Temporary Protection Directive, where is the problem? Where is my problem? The problem is that I would say is a structural problem. So the conflict in Ukraine, in its magnitude, can be compared to the growing instances of climate change induced migration. These are two different phenomena, but they are both exemplary of a new trend, of a new emergency in the global asylum regime. The emergency is represented by the fact that mass movements of people are more and more common nowadays. And the preamble of the Temporary Protection Directive itself highlights that mass influx of displaced persons have become more substantial in Europe in recent years. However, temporary protection is not the answer to this growing phenomenon. Temporary protection is just designed as an emergency scheme, allowing states to provide immediate protection, but it carries the risk to allow states to escape from their international obligations under refugee law. In addition, it raises barriers to the proper social integration of individuals into host societies, since it's hinged on the prospect of swift returns into home states. For example, Turkey adopted a temporary protection scheme in 2014 for Syrian asylum seekers, but the scheme has its own drawbacks. For example, it does not specify the duration of the protection afforded, or does not allow access to the refugee status determination procedure. So even in Europe, the adoption of the Temporary Protection Directive is not free of legal dilemmas. It will generate a number of considerable problems in the long run. And just to mention one, what will happen to the asylum applications filed after the expiry of the temporary protection? There is a rule on the examination of asylum applications within the directive, but this provision fails to mention which EU country exactly will be responsible for the examination of the asylum applications filed in the EU, and this will prove to be a problem since people enjoying temporary protection in the EU, according to the directive, are free to move freely in all the EU member states. They can decide wherever, they can basically reside wherever they want to reside. And this is very different from the classical Dublin system. So this is a real problem. This will prove to be a real problem. Will EU member states actually show solidarity in sharing the burden of the massive numbers of asylum applications which will arrive, which will be filed after the end of the temporary protection? Or will people remain stuck in a legal limbo for years while EU states fight over which one is responsible for their final reception and for the examination of their asylum applications? And with these questions, I think I'm done, and I thank you all for the attention.
Thanks indeed, Francesca. And in fact, actually, that's quite a nice one to go immediately after Catherine's presentation, because it raises this question about whether there's a whole set of cases outside kind of the refugee framework that might usefully be addressed through something like temporary protection. I think we have Dr. Gillian Kane back with us. Should we give that screen sharing another try, see if it happens?
I am back, and hopefully you can hear me. Unfortunately, it says that the host is disabled screen sharing, so I feel like I'm having a range of technical issues here today, but I'm not sure if there's something that you can do from your end otherwise.
Jane, I don't know if there's anything we can do perhaps to make Gillian co-host. Let's see if that works. Okay, so I think you're now co-host. Let's see if we can share your screen now.
Yep, that's me, and hopefully you can all hear me. And my apologies, very untimely cutting out of the internet from my side, but hopefully I'm back now. So
why don't you restart from the beginning? Yeah, brilliant. I'll start again from the beginning. So as I said, today I'm going to be presenting a paper really which at its core argues that a broader approach, one that more concretely embraces anti-trafficking law, is actually needed in discussions on reform of the global refugee regime. So the focus isn't on reform as such, but rather a closer engagement with international obligations that have the capacity to enhance protection within the global refugee regime. And obviously in this presentation, the focus is on international anti-trafficking law. So very briefly, what I'm going to be discussing is, first of all, what is the problem? Then looking a little bit at the international anti-trafficking framework. Obviously, for the purposes of time, this is going to be the broad strokes of the framework.
Looking then a little bit at the interaction between international anti-trafficking law and international refugee law, and seeing where those points of resonance and dissonance are. And finally then, ending on a positive note and looking at some examples of promise with a focus on Greta, which is the Council of Europe's group of experts on action against trafficking. Before that, I want to very briefly just outline, just so we're all on the same page, what is human trafficking? There's often sort of conflicting conceptualizations on this, but in the Palermo Protocol, which is a protocol to the UN Convention on Transnational Organised Crime, the internationally accepted definition is laid out. And here in it, we have 3 key elements, which you can see on the screen, and these have to be cumulatively fulfilled for conduct to amount to trafficking. So we can see here that ACT encompasses recruitment, transportation, transfer, harbouring and receipt of persons, means, force, but also other coercive and deceptive means. And the purpose broadly is exploitation. So we can see here that it's quite a broad definition, and there isn't, contrary to sort of some thought, there isn't a cross-border element in the definition. And there also isn't necessarily movement when we see that harbouring also could be an act that, if there's a means and a purpose, could amount to trafficking. So just want to keep that in mind as we go forward through the presentation. What is the problem? Well, I've put a couple of screenshots from recent weeks on the screen that really highlight the problem. This is not a new problem. As I say, these are from recent weeks, but these are just give a snapshot to the fact that in the context of international protection, trafficking is a problem, both on the journey towards protection, but also in context of protection, and even after international protection status has been granted. What this really means is that the risk and the reality of trafficking is observable at all stages of the asylum process. And the upshot of this is that in a context where international protection is owed, what is encountered and experienced is further harm, often exploitation, and often exploitation amounted to trafficking. And that is definitely a problem worth considering. It's also worth noting here that trafficking may also be the basis of an asylum claim, but I'm not going to focus as much on that in this presentation. It is worth bearing in mind though. So what is the International Anti-Trafficking Law Framework? Well, I've highlighted here the main global instrument, but also a couple of regional examples as well on the screen. So globally, the key instrument is the Palermo Protocol, as I mentioned. It's a protocol to the Convention on Transnational Organised Crime. It doesn't have a monitoring body created by it, but there is a new sort of monitoring peer review mechanism just getting going. Regionally, a couple of examples. So in the European context, the Council of Europe Convention, which mirrors the Palermo Protocol and extends protection, actually, particularly when it comes to rights, EU directives. And then in Africa, I just want to draw your attention to the African regional context. The Malabo Protocol, really interesting development because it's an international criminal law instrument that criminalizes trafficking as an international crime without being attached to a crime against humanity, quite novel in its approach. And the East African Community Trafficking in Persons Bill. Both of those instruments are not yet enforced, but I think something to watch in the future, especially in the asylum context. So for the purposes of time, we're just going to focus on the Palermo Protocol and the obligations that are in it. I've sort of given the broad strokes here on the screen. So obviously one of the key things about the protocol is it defines human trafficking and really sets out that definition. Is it fit for purpose in the asylum context? Big question, but broadly, I think we can look to the fact that it is a broad definition. It's able to encompass a lot of harm that is experienced in the asylum context, both on the journey and at destination. I think where the weakness is that the conceptual boundaries of this definition are still disputed, and there are some misunderstandings. So I think that's where the hindrances are in terms of its capacity to be of use in the asylum context. And with any kind of status, always those on the margins and those who fall outside of the definition is also a problem. We can see then Article 5, criminalisation, but I wanted to highlight two core sets of obligations in the Palermo Protocol: prevention and protection. These are really key, and I think these can really be highlighted in the asylum context in a way that they're not always. So the prevention obligation, states are required to take measures to educate, cooperate with NGOs, alleviate trafficking risk factors such as poverty and lack of opportunity. Protection, a range of protective measures, but these measures hinge upon identification. So it's really key that there's an awareness of this in the asylum context, because protection can't be accessed where identification isn't happening. And then I just want to briefly highlight as well the border measures provision. This is a little bit more problematic. It basically requires states to strengthen border controls as necessary to address trafficking. And this can actually include carrier sanctions. I'm sure in this gathering, I don't need to overstate the concern here with regards to asylum. I don't need to spell it out, but I think, you know, by bringing this framework into the center of the discussion on refugee protection, I think we can problematize these things more and really get to grips with some of the more troubling aspects of the framework, as well as the positive aspects of the framework. Moving on then to look at the kind of interactions between international anti-trafficking law and international refugee law. I mean, again, broad strokes here, but just to sort of provoke some thought here, you know, both regimes focus on protection, and Stoyanova speaks about the ways in which they positively complement one another. I would even go beyond that and say, you know, there's added value in both regimes. And actually, you know, we've seen that there are distinct obligations in the anti-trafficking regime that can actually enhance the overall protection of refugees. Likewise, there are protections within the refugee regime that can actually reduce the risk of trafficking. So it's also not just looking at the interactions, but the added value that each bring. That can only happen if they're both considered. There's also some problematic interactions. So the border measures provisions coming up against and interacting with gaps, access gaps in refugee law, which I'm sure we're all very aware of, and maybe those things working together to exacerbate risk. That is problematic. Things like the Dublin system, which really de facto sort of encourages people to remain under the radar a bit longer, exposing them to a greater risk of trafficking. So there's questions in terms of states' preventative obligations there. And then what I'm arguing here is this absence of explicit connections in practice. So if you do a word search of the Global Compact on Refugees, you'll see very, very limited references to trafficking. And that sort of persists across the trafficking framework as well. And so this absence of interaction is something that we can actually work on and move towards a bit more connections. Some signs of promise then, just very briefly. It's not all discouraging. I think in the last few years, we've definitely seen more of this. So interventions by UN special procedures mandate holders. At the end of 2021, the political declaration on the global plan of action to combat trafficking in persons actually explicitly acknowledges the trafficking asylum nexus and the vulnerability of refugees and asylum seekers to trafficking. UN agencies, and then, as I say, the Council of Europe's GRETA. GRETA is a monitoring body established by Article 36 of the Convention, and it really undertakes a number of functions because it's been empowered by the treaty. Country reports, obviously deals with trafficking as a whole in the countries periodically, but it does often focus on the asylum context. And there we see the state to GRETA dialogue about what they're doing to interpret these obligations in the trafficking or in the asylum context. The only 2 times that GRETA has used its urgent procedures mechanism have both been for trafficking among refugees and asylum seekers. And it also addresses it in its thematic report. So here we see it really what could be in terms of bringing these 2 frameworks and contexts together. I think GRETA is a really good example of that. So to sum up, the risk and reality of trafficking is observable across the asylum context. So I think this really calls for an approach that more concretely brings in anti-trafficking law squarely into the discourse, not just about trafficking as the basis for an asylum claim, but about how these obligations in anti-trafficking law can be operationalized in the asylum context to enhance protection. Even where there are weaknesses, I think bringing it more squarely into the discourse can encourage dialogue on how we overcome these weaknesses. So, of course, it's not the only thing that's needed in reform or improvement of the refugee protection regime, but I think it can play a valuable role, and I do think it warrants further dialogue. So I'll end there and hand the floor back to the chair. Thank you very much.
Many thanks indeed, Gillian. A very crystal clear presentation, if I may say so, on an area that is really quite complex. So I think you covered a good deal of ground there. And I'm sure that there'll be a number of questions and comments in the chat box, asking about trafficking, which is always a topic that attracts a good deal of interest. So moving on to our final presentation, I'm really pleased to welcome to the panel Dr. Zvezda Svedsta Vankova from Lund University in Sweden, and she'll be talking on asylum, return, or circular migration. What's next when labour migration fails to provide a durable solution for refugees? So you've set yourself a big question there, so let's hear what you've got to say about it. Over to you, Svedsta.
Thank you, David. Hello, everyone. I'm really happy to be here and to have the opportunity to share with you some very preliminary ideas, and I'll be very happy to hear your feedback on them. So without further ado, I would like to share with you a little bit, to give you a bit of background where this paper is coming from. So it's part of a big research project that, that I'm leading as part of my postdoc, and it's a social-legal project which draws on 2 case studies, namely Germany and Sweden, and more than 40 interviews that I have conducted both internationally at national level. So the first 2 papers that are, one of them is already published, the other one is on the way, dealt with the legal basis on the EU law to develop complementary pathways based on labor migration. And the second one dealt with the political and legal feasibilities of such approach when it comes to the implementation at national level, namely in Sweden and Germany. And the last one is the one that I'm working on right now, which basically wants to come full circle and to see what happens if people manage to enter as labor migrants but cannot stay. So what are the challenges that we see there? Just to briefly remind you what we're talking about, because I'm sure the audience has heard already about complementary pathways based on labor migration. In UNHCR's definitions, these are safe and regulated avenues for entry or stay in another country for the purpose of employment with the right to either permanent or temporary residence. And just to give you an idea, this could be based on existing immigration systems that are adapted to facilitate refugees' access to labor migration options, or this could be temporary or permanent skilled entry arrangements specifically designed at supporting refugees, for example, as the displaced talent visa that currently is being piloted in the UK. And finally, which is not in the focus of today's presentation, this could be humanitarian channels that provide a secure status to refugees and then facilitate access to employment, such as the community sponsorship initiatives that we have seen in Europe and beyond. Who are these pathways for? I think that's very tricky question, and it took me quite some time to pin what's the exact target group of these measures. I think if we take a look at the GCR, we see commitments to explore labor migration for recognized refugees. If we take a look at the Global Compact on Migration, we also see this under the promotion of availability and flexibility of pathways to regular migration, which also means that asylum seekers could also benefit from such complementary pathways. If we take a look at UNHCR's and the EU's understanding, which was firstly introduced under the new pact, we also see that the target group is people in need of international protection, meaning people who are recognized as refugees, but also de facto refugees who haven't went through the status determination process yet. So next, when designing such pathways, of course, we need to keep in mind both refugee-related international standards, but also standards that are dealing with the regulation of labor migration and the rights of labor migrants in particular. So here there is this cross section of all these rights that needs to be kept in mind, and standards when we design them, such as right to work, the fundamental labor rights, such as right to join the trade unions, or equal treatment when it comes to remuneration and working conditions, but also access to family unification, especially in the EU context, and access to a more permanent status called long-term residence on the EU law. So just to give you a very brief, again, overview for the sake of time of what are the challenges to enter as a beneficiary of complementary pathway based on labor migration, and then I'll move on to challenges related to return and an availability to secure a residence. So when it comes to entering, unlike the EU citizens, third country nationals face 27 different labor markets in the EU. So there are myriad of entry conditions, both at EU level and national level. And these are unsurmountable for people in need of protection, unless there is some state facilitations that makes this access easier. Furthermore, none of the instruments we have in the EU actually gives access to permanent residence, immediate access, as we have, for example, in Canada, which is a front runner in this regard. We have different permits with different validity and duration. And even if people manage to come as beneficiaries of complementary pathways, then there are problems of securing the long-term status. There have been a lot of problems with labor exploitation. And some of my interviewees, for example, in Sweden, said that because of the dependency on the employer, a lot of the people who have used these pathways have really been exploited. And here there is a quote: they kept their heads down even if they had to work for 18 hours a day for half a salary, because they really wanted to secure this permanent residence after 4 years of working for an employer, and they can change it only after 2. So a lot of them are really putting up with a lot of exploitation only to be able to stay. So what happens if these people made it to a member state as labor migrants, but for some reason they cannot prolong their work contracts? What are the options? So I think this, and I'm open to more suggestions. So far, I've thought about 5 things, 5 options. They could look for alternative employment if the national legislations allow them to stay without withdrawing their permit. They can shift to a different state, again, subject to the national legislation in place. They can claim asylum. They can return to the country of asylum. They can be returned to the country of asylum, country of origin, where possible, or they can engage in some sort of circular migration. And for the sake of time, I'll focus only on the last 3. So claiming asylum, of course, is a right under international EU law, and all these people should be able to, of course, benefit from that right. But the literature, and so the literature that we have so far and my interviews show that generally this is a last resort measure. So people will really, really try to stay and will only apply for asylum if there is no other way. If we take a look at the data concerning Syrians, actually we don't really have such hypotheses, people entering as labor migrants and then applying for asylum. It was actually vice versa. But my interviewees pointed to the fact that there will be very limited chances for successful claims after someone has actually worked as a labor migrant and resided as a labor migrant for so long. The Swedish legislation was more liberal and allowed the possibility to switch back between labor migrant and asylum seeker, but this has been now, this opportunity has been limited now. I also think that this issue will require serious case law analysis, but I don't think that there is much case law available on this shift currently. When it comes to Ukrainians, because I'm trying to make a comparison between the Syrians and the Ukrainians, we don't have that much data, but as it was raised by Francesca, we do see problems when it comes to applying for asylum under the TPD. And there is currently a case even pending in Bulgaria challenging the restriction of access to asylum in Bulgaria and prioritizing only TPD applications. When it comes to return, of course, we have the principle of non-refoulement. And I think a lot of the policymakers that I interviewed are quite aware that probably these people won't be able to be returned. And actually, this is one of the problems why they do want to start the conversation about facilitating such complementary pathways and now posing this idea. There's so much literature on that, so I won't go into details, but you all know Europe is relying on readmission agreements. They're highly inefficient in practice. So in the end of the day, what happens is that we end up with creating precarity for these people and putting them in a legal limbo. And of course, as it was already mentioned by the previous speakers, we have different approach to Syrians and Ukrainians. I won't go into details on that one. And then finally, circular migration. I have done quite some work on this topic. So I can draw on my research and say that if we want to facilitate and encourage circular migration through a right-based approach, we need to have at least several measures in at least several policy areas. We need to have entry and re-entry conditions based on formal legal statuses. We need to have residence statuses, work authorization, social security coordination. And I must say that even the instruments at the EU level that we have in place do not cover all these requirements. The Blue Card Directive, which is for highly skilled migrants, comes closest to covering all these measures, yet there are problems in practice, and we have now currently pending case in front of a Dutch court looking into the problems created by highly skilled circular migrants and the vagueness of the directive about that matter. And the interviews that I've done, especially with UNHCR officials, would say that this approach is not providing permanent solution, and it's not really promoted by them. But I think, in my opinion, it could work if people have managed to stay in the country and gain a secure status, even like citizenship, and then they can actually engage in circular migration back to their countries of origin if that's safe. If we look into circular migrations before gaining secure status, I don't think this can work. For Syrians, for example, based in Lebanon and Jordan, we know that there is no full legal status for them and not a real solution in these countries. There are exit fees, there are no re-entry policies. So this all goes really counter the idea of circular migration. We also potentially would see problems with granting them visa to actually start the circular migration journey. So there will be a need for some sort of a bilateral agreement or other interstate cooperation, but I think the Jordan Compact is already showing us that this is not a very promising idea when it comes to these countries. When you take a look at the Ukrainians, it's again another story. Most of the Ukrainians, the refugees, are currently in Poland, and Poland has been heavily relying on Ukrainian forced labor, and there has been a circular migration scheme running for many years, which allows them to circulate and to basically settle in the country if they want to, and if they have an employer who can offer them a secure job. So basically it's flexible, it allows them to circulate, to settle, but it also doesn't come without any problems. We have noticed a lot of problems with exploitation, informality of work, and also problems with, again, social security coordination implementation. So my very preliminary conclusions, because I'm still analyzing my data, are that if policymakers want to facilitate complementary pathways based on labor migration for refugees, they really need to realize that the option to fall on the asylum system is part and parcel of this approach. In reality, these refugee workers would use this only as a last resort measures because they're aware of the consequences and of the lack of clear path that the asylum procedure can trigger. But if a clear and fast path to secure residence is key in the design of such complementary pathways, and it can allow sustainable return and circular migration options rather than actually people falling back on the asylum system. So I think if countries which are willing to design such or to pilot such schemes would like to limit the cases of people falling to the asylum system, they really need to think about creating easy access to secure residence rather than temporary migration options only. Thank you very much.
Many thanks indeed, Zvezda. Okay, so we've heard from all four panelists, and I'm really delighted to see that there are a good number of questions that have been posed in the chat. I'm going to go back to the panelists now, having heard about 4 different ways in which alternative approaches or frameworks might be brought to bear. I'd like to ask the panelists, though, if in responding to the questions that you've seen in the chat, and again, we'll go in the order that we started, so beginning with you, Catherine. For all of the panelists, I wonder if you could just tell me a little bit. First of all, the conference is about improving the refugee regime, and your papers are on a thematic panel about improving the refugee regime. And so you've presented, each of you, a different kind of approach or framework that relates to protection or movement in some way. But it would be really good if you could start off your responses to the questions by answering the question of whether you could say something more about what the problem in the refugee regime is that your presentation is addressing, and how you think the frameworks that you've addressed in your presentation deal with that problem. So if you could start with that, and then you've got questions from a number of other panelists and participants as well. So I'm going to give you each about 5 minutes to answer that and other questions that you've got. And again, we'll go in turn. So Catherine, over to you.
Okay, so thank you for the question. I think that it's very important to address this issue. What's justified this research, it's exactly the fact that the number of unprotected people is a cause of concern, considering that it's a common cause of migration, environmental disasters, and in states' incapacity. And both these causes are not contemplated by the objective concept of refugee developed in 1951 or even in the 1984 Cartagena Declaration, which is a little bit broader concept. So in order to provide some sort of protection, and by addressing this point, I'm already responding these implications and relations for refugee law. The idea of humanitarian visas in the Latin American practice is to provide some sort of protection to those that cannot be recognized as refugees, or cannot fulfill would be like this objective concept placed in the Declaration of 1951 or in the Declaration of 1984. So also there are some positive developments. I presented the shortcomings, the problems, but the best development that I can highlight in this opportunity would certainly be the access to welfare systems and some sort of regularization, and which can be also the humanitarian visa concession could be understood as a step to a durable solution, because most provisions do provide the possibility to those who are granted the humanitarian visas or humanitarian measures, other humanitarian measures, to apply for a permanent residency after the expiration of their visas. It's not a guarantee, but it's a possibility. So this is, I believe that I already answered your questions, and this is all the reason of this research is exactly the fact that the refugee regime cannot provide a solution to all causes of currently causes of migration. So we need to provide another complementary pathways, and humanitarian visas would be one of it.
Thanks, Catherine. If you don't mind me just picking up on that point, I mean, it's an interesting argument, but then why not have another Cartagena Declaration that extends the definition to these other classes of person who you're talking about? Why not? Why choose some other kind of status? Why do you think states have taken that route this time around? Is there any data on that?
Well, by Latin America experience, what we do have, it's that the refugee regime was not able to deal with all the migrations, and there were some specific contexts, such as the Haiti situation that needed a response, and there wasn't a regional political will to start to create or develop another declaration, and all the difficulty to find a way to address as a region to this situation. So each country started to receive, like Brazil received a lot of Haitians and needed to provide some sort of answer. And the answer that it came across was exactly, oh, so let us try to solve this situation and not have to address it in a general aspect, which is a problem because we have this ad hoc application. When there is a crisis, then we deal with the crisis, but we're not facing the whole problem.
No, thank you. That's a very illuminating answer. And it sounds like this is something that, rather than being developed at the international level and, if you like, filtered down, in fact goes the other way. It's individual states in a kind of fragmented pattern, building up domestic law provisions to deal with these kinds of cases. And I should say actually that there's some of these provisions form the basis now for regional frameworks which do in fact address cross-border displacement in the context of disasters and climate change. So if you look at the Regional Conference on Migration, the South American Conference on Migration, they have regional guidelines, albeit not in treaty form, but if you like, as kind of policy or soft law that say, you know, use these humanitarian visa or humanitarian temporary residence protections as a, you know, in a kind of uniform way in these particular contexts. So it's interesting, I think, the way that you've presented, you know, there's this kind of domestic stuff and it's building up towards the international, at least in relation to that category of person. Very, very insightful. Thank you very much. Okay. Were there any further questions that you wanted to address from amongst the chat, or is that it?
If I would like to address questions, is that it?
Oh, did you have any further questions in the
no,
chat?
no, thank you.
Right. Good. Okay, in that case, Gillian, you are formally second, so we will go back to you for your responses, please.
Thanks very much. So yeah, just to come back to your question there about, you know, what is the problem in the regime, the refugee regime that I'm hoping to tackle, and I mean, I think, you know, at a very basic level, it's what I sort of mentioned in the presentation, which is people are coming seeking international protection and encountering further harm, and, you know, harm that can be categorized as trafficking. And to me, I find that quite problematic. You know, it's an international protection regime, and, you know, there's an obligation under international law to provide that protection. Of course, protection from persecution, but certainly, you know, it shouldn't be that people are encountering further harm, you know, that they wouldn't have encountered necessarily but for their displacement. So I think that at its core, I mean, there's a lot of offshoots from that, you know, in terms of part of it is the lack of safe and legal routes to migration. You know, that's aggravating risk. Part of it is maybe capacity issues in the host country, you know, where there's large scale influxes. So I feel like there's a core problem, but there's lots of sort of offshooting problems on it. So it's hard to pin down, you know, one thing. But I think, and obviously, you know, focusing on anti-trafficking law isn't the sort of one quick stop solution to all the problems. I think what my argument is, you know, let's bring this a bit, it's sort of still sitting, in my view, a little bit on the periphery in a way that I think international human rights law isn't. You know, it is more in there. You know, some people are even saying it you know, it sort of surpasses international refugee law in protection. But anti-trafficking law, it's there, but I think it's on the periphery a little bit more. And actually, there's some really key obligations in there. Part of me wonders if it's on the sidelines a little bit as well, because it's a little bit of a different nature. You know, it's set sort of in a sort of transnational organized crime context, not necessarily in the European region, but it does sort of maybe fit or seem to fit a little bit sort of disconnectedly. But I think really bringing those two things in can only help in terms of really teasing out what those protection and prevention obligations mean. And I think, you know, that can only improve things by continuing to focus on that, you know, training people who are working in those contexts to recognize trafficking and to understand, you know, the breadth of trafficking. I mean, and just to kind of like I suppose this links in with a little bit of the question from Aileen, so I might just move on to that as well. She had asked, what do you make of the moves of states to use the argument of combating trafficking to further attack rights of refugees on the move? So attempts to construct trafficking as overlapping with smuggling, criminalized travel. And part of that comes into, you know, we often see trafficking being used in this way. I think there's two main ways why that happens, which I think could be mitigated if we more concretely engage with anti-trafficking law in the refugee protection. So one of them, I think, is a conceptual misunderstanding of what trafficking is. I think we see that often in the media, you know, particularly in the UK of late, even sort of underpinning policies, and this idea of combating trafficking. And if we look at the definition, like coming back to this definition, it may not, I mean, there is probably trafficking going on there, but it may be something slightly different. And I think, you know, a misunderstanding and maybe the trafficking being misused or being pitted almost as this, and part of this is, you know, the criminal justice lens through which trafficking has been dealt with, but that idea of, you know, fighting the traffickers as a sense, and almost pitting people against each other. Whereas if we look at trafficking as kind of this broad definition that encompasses a range of harms, I think that, you know, education and training on what trafficking is can start to, I mean, it's a slow process, but start to really unpack. And there's a lot of really good work going on in the anti-trafficking field of really starting to unpack those that definition and come against these myths and these ideas of like an ideal victim and an ideal perpetrator. So I think one of the things is to really move towards a better conceptual understanding of what trafficking is. And the other thing then, in terms of states using this to you know, these arguments to combat trafficking, I think part of what you're getting at is probably the problematic aspect that I brought up in that actually sits, you know, in the Palermo Protocol, which is this border measures provision. It is really problematic. There's no two ways about it. I think even if we take asylum out of it completely, you know, in my own work, I had sort of argued that in some ways that provision actually contradicts the, you know, the spirit and the letter of the protocol in general. If we look at what we know about, you know, tougher border measures and carrier sanctions on trafficking risk generally, it is problematic. I think though, again, by bringing this a bit more into the center of discussions on refugee protection, you know, we can really dial down into what does this provision allow and not allow. And if you look at the wording of it, you know, I think a very, 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 you know, narrow interpretation of it is appropriate. There is also what's known as a savings clause in the Palermo Protocol, which does say that nothing in the protocol can conflict with international refugee law. So again, I know it's getting down into the nitty-gritty of like treaty interpretation, but I think that's what's needed in order that, you know, states aren't relying on this provision and saying, oh, well, we need to do this because, but actually, you know, the narrowest interpretation possible. So again, I think by pulling this in to the conversation, we can deal with, you know, operationalize the positive aspects, but also grapple with and mitigate the negative impacts of some of those more problematic provisions, which again, you know, you've noted, Aileen. And then, oh, sorry, go ahead.
Gillian, I'm going to give you 1 minute and then we're going to move on to the next, and perhaps the other questions you could come back to at the very end.
Yeah, I mean, there's just a question from you, so I can do it now or later.
Why don't we come back to that one at the end, as
No worries.
One bite of the cherry, as it were. Thanks, Gillian. On to our third speaker in that case. So Francesca, would you like to come in on the questions you've been asked? I know you've got quite a lot, but I think that there are, you know, they're down two main lines. One, you know, what's this got to do about improving the refugee regime? And second, all these questions about prima facie.
Yes, thank you, David. So yeah, basically I received those 2 or 3 questions. There was one about people crossing from Moldova, which unfortunately I do not have the answer for. I guess there's no problems with those people. I know that there's a problem in Moldova itself. Actually, they are really dealing with a huge influx of asylum seekers, and they really do not have the tools to deal with that. So maybe the problem is from the other side, is on the other side, but again, I don't have data on people crossing Moldova. So I don't want to really risk saying something which is not true. About the questions I received on the prima facie and your question, David, on the appropriateness of the temporary protection directive and on what's wrong, what's to improve in the global refugee regime. I really just wanted to make the point that mass displacement, at least in my view, it's going to be more and more common in the future, and we really need to put in place a framework to deal with that. And for example, when I was talking about Poland, I was thinking about the fact that the state itself went to NGOs and churches and civil society organizations, asking them, how did you do this? How did you provide assistance in such a quick and effective way straight at the beginning of the crisis? So probably, for example, an idea would be to kind of reinforce the link between state and non-state actors in actually building in capacity building mechanisms, in building a common knowledge on how to practically deal with mass influxes of refugees. And for example, when we talk about climate change, even the temporary protection directive couldn't really be helpful, because I mean, the definition contained in the temporary protection directive states that the influx of people must come from the same country or geographical area. So it would not apply to, for example, climate change induced migration from a lot of different countries. And all, as the law stands today, it would only be applicable to like a restricted geographical area. And so that's the main problem I see with this. But actually, I've detected a lot of potential problems with the temporary protection itself. As you were asking me, for example, its activation was really discretionary. You need qualified majority voting. It was not activated with the so-called European refugee crisis, even though Malta and Italy explicitly asked the Commission and the Council to do so. In 2011, it was refused. So really it boils down to the political will of the Commission and the Council to activate the temporary protection directive. Also, there's issues with the discrimination in the application of the directive, because in the list of beneficiaries, there are some people who are not included. So there is, I had it somewhere, I will find it later, but there was an issue with third country nationals, for example, people coming from North Ukraine or countries of the European Union. So, for example, for third country nationals and stateless persons which do not have permanent residence in Ukraine, member states of the EU they do have a choice whether in granting them protection or not. So there's a clear issue of discrimination here, which has been repeatedly highlighted. So yes, it was a nice, let's say, a generous move on the part of the European Union, especially in light of the fact that people are free to move around in the EU, crossing national borders, but also has its own drawbacks. As it regarding the questions on prima facie protection, yes, I mean, from the perspective of international law, there is no barrier to granting refugees from Ukraine the status of refugees on a prima facie group basis. In fact, Ukrainians and people within Ukraine are currently, given the intentional bombing of civilian structures, they are currently at a risk of persecution based on their nationality. I think, though, that states actually prefer the temporary protection status because they can use it to kind of downgrade the obligations they have under refugee law. For example, there are some rights attached to the refugee status which are not included in the in the temporary protection directive, and also again, as I was speaking about the exclusions in the list of beneficiaries, that's also a way to kind of exclude people from protection. And so, yeah, I think that this was the main reason why the prima facie approach could be working in this case. So the prima facie approach, meaning the recognition by a state or UNHCR of the refugee status on the basis of objective grounds, such as the war in a specific state. But it was kind of maybe consciously avoided by the EU in order to leave states free to kind of restrict the plethora of beneficiaries and the granted rights. Thanks.
Many thanks indeed, Francesca. And yes, I mean, there's a parallel between temporary protection and humanitarian visas in the sense that they're both to some degree discretional. And there probably are some differences between TP and refugee status in the sense that, you know, there are questions substantively about who counts as a refugee or not. But then when you get to the procedural aspects, you know, the difference between the procedural basis for temporary protection, the procedural basis for prima facie refugee status recognition, I mean, you know, I'm not entirely clear that those two things would be as distinct as is sometimes imagined. So, you know, it's certainly an area of discussion, and you've attracted a good deal of, you know, comments and questions around that. So thank you very much. Zvezda, over to you for your responses, please.
Thank you. So I'll start with the question of David. The problem that these complementary pathways are addressing, the problem of the Refugee Convention, is that we have problems with absence of any rules on how refugees would access the protection in another state as party to the convention. I think that's pretty straightforward. But going back to what you just said, this is yet another discretionary mechanism that states can decide to apply or not. And this ties very well into one of the questions in the chat that I got on what are the numbers of places and what's going on currently in the world. And I think you won't be surprised if I tell you that we have really little experience so far. We are still in the pilot phase. I mentioned that the front runner is Canada, and Canada has committed now in a second pilot to open up to 500 places a year. We have also Australia, we have the UK. The places are smaller than this, and then in Europe, we are about to start piloting. There's funding provided by the EU, and there's a pending pilot in the UK, Portugal, and Ireland, and Belgium. So watch that space if you're interested in that. The main problem for states, according to the research I've done so far, is that this approach requires mixing of labor migration and asylum, these two domains, which are politically perceived as two separate domains that should not be mixed. And this is the official political line. But if you look into reality, what the countries are doing, they are constantly mixing it. And I can give you several examples of that. For example, let's say the tolerated status in Germany, where asylum seekers with unsuccessful claims can become slowly workers. When we have a refugee with recognized status, countries are using the access to workers integration, so the refugee can become a worker, a migrant worker. Students, and that pertains to another question that I got in the chat, students, after they graduate, are given an opportunity under EU law to look for a job or to start a business for a period of time so they can become migrant workers. We are also mixing these two in resettlement, where countries are introducing the integration potential and looking into the education and skills of refugees. So this is happening all the time, and now it's even explicitly happening at EU level, where we have the Blue Card Directive regulating admission of highly skilled migrants, for the first time introducing a double status where beneficiaries of international protection under EU law can also become highly skilled workers. So what is the problem? I don't know, but this is really comes from the strong message that that interviewed policymakers and state officials sent to me that this is really a blocking problem for most of the pilots in the countries. There was a question about the students and whether if refugees enter the students, they encounter the same problems as labor migrants that I outlined. Well, there have been programs, for example, a day-a-day program for Syrians in Germany. Unfortunately, there is no data what happened to these people who are admitted as students. But I would, as I said already, usually, at least on the EU law, at least for the member states that are applying the Justice and Home Affairs state legislation, students will have some time to look for a job or start a business. And depending on whether they manage to secure a job or start a business, I guess it will depend whether they'll encounter these problems that I talked about today. But I haven't done research on that. So I think there's plenty of research projects going on these days, so you can definitely take a look. And then the last question was on climate-induced displacement and whether this labor migration-based complementary pathways can actually be suitable option for such people. And I do think, yes, absolutely. Actually, I'm planning to write a paper on that with a colleague who specializes in climate-induced displacement. And I do think that this could be a good idea, but again, I should stress that the shortcomings of this approach are that usually mainly highly skilled people will have access to this and easier access to this. And the problem is that we need to reach out to these people. They need to know about the opportunities that are available in different countries. We need to match them with employers that are in need of their skills. And employers are also currently not so open to this idea. There's a need of work on national level, national coalitions, which could actually create some pilots, create some proof of concept. So actually this idea can gain momentum, but also be aware of all these pitfalls that I also talked about today, because it's not only a matter of entry and securing access to territories, also what happens afterwards. Like keeping in mind that in Europe, we do not have immediate access to permanent residence, so it's not an immediate access to durable solution, then at least there should be a very clear path to some sort of secure status within reasonable time that people in this situation can rely on. I can talk about this for hours, but I stop here. Thank you.
Thanks, Vesda. And there's a very interesting scheme of circular migration. There used to be between Colombia and Spain, where Colombian IDPs affected by floods would be taken on circular migration routes. So well worth a look at, a very, very exciting scheme. In fact, I was pleasantly surprised at how many of you panelists touched on this issue of climate as a gap, and some of the proposals, whether temporary protection, humanitarian visas, or indeed circular labour migration schemes, might be a way of kind of complementing the gaps we see in that regime. Just drawing the panel together to draw it to a close, and I'm sorry, Gillian, you and I will have to discuss that last question when we speak next week. But it does really sound like, you know, I really appreciated not only your presentations, but the way that you came back in discussions to really link this to, you know, where are the problems in the regime? How do these schemes serve as possible ways to address those problems? And I think every single one of you really drew out not only the theoretical, but some of the practical aspects of that. A really key part being, okay, it's not just about gaining entry, it's about what happens after that. And I thought, you know, Francesca, you had some really interesting things to say about TP in that regard as well. Unfortunately, our time is literally in the last 30 seconds. So it remains only for me to say many, many thanks to all four panelists and congratulations on excellent starting presentations. To all of the rest of you, many thanks indeed for the questions that we received in the chat. Very, very pointed and precise, really thought-provoking. We have 20 minutes. You can join the online coffee session if you wish to do so. Otherwise, we'll see you in 20 minutes at the second of these breakout panel sessions. A very, very warm welcome again, and we will see you very shortly. Thank you.